So good morning, everyone. Respected speaker, ma'am. Thank you for being here. At the same time, waiting for another 5 to 10 minutes without having me. And at the very outset, I would like to thank our Royal Global University for giving us this opportunity and platform to organize this webinar, and our Vice Chancellor, sir, for guiding us and at the same time allowing us to conduct this webinar on this specific topic, that is IPR and innovation from patent law perspective. So today we are having our guest, our speaker, Dr. Topi Basar ma'am. Before starting the webinar session, I would like to give a brief introduction of our speaker ma'am. She's renowned in the field of IPR, at the same time contributing a lot to the teaching and research. Before joining at NLU Assam, she was working as a faculty at the Faculty of Law at Delhi University. She is having more than 14 years of teaching experience, and in fact did her PhD on traditional knowledge, benefit sharing. She has participated at various national and international seminars, workshops, published more than 10 research papers in reputed journals, one book, and lots of book chapters in edited books. She was an expert member at several interviews conducted under the Staff Selection Commission. She has participated at Young Global Leadership Meet at Melbourne, Australia, selected by Delhi University. And she is the first person from Arunachal Pradesh to get LLM and PhD degree. And currently she is the head of Center for Advanced Research on IPR. So ma'am is having a very good, vast profile and having a very expertise in IPR issue. That's why we have selected ma'am. At the same time, I would like to thank ma'am for accepting our offer or invitation to be a speaker on this special webinar topic. So over to you, ma'am. You can now start.
Good morning, everybody, to all the participants, and thanks to Global University, the Honorable Vice Chancellor, for having me here today. It's a privilege for me to be addressing all the participants across the diverse field. Can you tell me a little bit about the background of the participants?
Yes, of course, ma'am. Here we are having our main focus is our students, Royal Global University students, basically the LLB students and LLM students. Apart from LLB and LLM students, we are having students from outside of this university, since it is widely circulated to other law colleges and universities across India. And at the same time, our faculty members, they have also joined here in this webinar. So mainly our targeted audience is the students, the LLB students, basically the LLB students and LLM students.
Hope all of you are doing well in this difficult times that we all are going through. Pandemic, this pandemic situation has affected all of us, but it's always good to have, to utilize the time in a fruitful manner, no matter whatever the situation may be. So I'm very glad to be addressing all of you, and I hope this session proves to be a fruitful one to all of you. And I have prepared a PPT, so I'm going to present to all of you so that it becomes easier, when you see things written on the screen and then speaking also at the same time, the impact of understanding is more. And after my lecture is over, we can have an interactive session. So I would like to request all of you, whatever issues and concerns you have, you may please write it down and put it across to me when we have the interactive session. Can you see the PPT on the screen?
That's there, ma'am. It is visible.
Okay, good. Okay, the topic for today's deliberation is IPR and innovation from the patent law perspective. To begin with, intellectual property is the most contemporary subject today, and it is easily one of the most popular. It is unimaginable how much it affects our lives today. We may not be able to say how it impacts us, but believe me, all of us uh, are part of intellectual property right in one way or the other. To put it simply, intellectual property is the creation of human mind in form of creative intellectual pursuits, resulting into new ideas and innovations. Intellectual property is the creation of human mind, in short. Now, whenever we talk about intellectual property, it is generally distinguished from general property, the concepts of general property. Now, when we talk about property in general, they are tangible in nature. And when I say tangible, it means properties have certain kind of a structure, boundary, shape, physical attributes, etc. I mean, when you have a property like land, okay, or a house, it has a physical structure, it has a boundary, it has a shape, and it has certain physical attributes, whereas intellectual property are intangible in nature because human intellect, human intellect has no limit or boundary. When we say intellectual property are intangible in nature, it means because it is got to do with human intellect, human intellectual abilities, and which has no limit or boundary, which has human intellectual pursuits have no limit or boundary, unlike general property. So therefore, the property is in general are tangible, whereas intellectual property are intangible in nature. That is the first distinction and the main distinction. Now, there are various forms of IPR. IPR is not one thing or one branch that we are talking about. There are various forms of IPR. They are a group of diverse laws. It's a conglomeration of laws such as copyright, trademark, patent, geographical indication, etc. And each one of these forms of IPR are different from the other in terms of its nature, in terms of its rights and enforcement. Copyright, as we all know, copyright is given for literary and artistic works. Whenever we deal with any literary and artistic works like books, cinematography, drama, music, plays, etc., it's the copyright which becomes applicable. And trademark is given for business, and it is basically business and services name and identification. Trademark is used as business and services name and identification. And patent is for industrial inventions. Patent is for industrial inventions. And geographical indication. Geographical indication is for reputed products which originates from a given specific geographical territory. And intellectual property right also includes subject matter like traditional knowledge and trade secrets. They are the new areas of IPR, so to say. Intellectual property right is dynamic and most evolutionary law. And when I say it is the most dynamic and evolutionary law, it means it keeps growing. It has a certain organic nature in it which keeps growing, it keeps developing. So new areas of IPR keeps on emerging with the development and at the pace with which innovation and creativity happens. Because innovation and creativity is a very dynamic phenomena. It keeps on growing. So IPR is the driving force. IPR is the driving force in knowledge and information-rich world. Today we live in an era which is a knowledge-based era. Knowledge and information-based era. And intellectual property is the driving force in this era of knowledge and information-hungry and knowledge and information-driven society that we live in today. And IPR is a product of globalization. It is a product of globalization which is enforced internationally through the WTO trips, okay? We will come to that later. And we will see, and we all know that intellectual property right and innovation are organically linked. As the one give rise to the other, we can say they are the two sides of the same coins because they thrive on each other. They thrive on each other. They are organically linked with each other. More innovation means more IPR. More IPR means more innovation, you know. So they are interlinked concepts and they are organically linked with each other. See, as I say, when IPR has an international dimension to it, IPR has a universal context. There is a universal context of IPR. And when I say universal context of IPR means the origin of intellectual property laws lies at the international treaties like WTO TRIPS, and before that also various conventions like Paris Conventions, Geneva Conventions, all that. So these have originated at the international level and then it has percolated down to the national level. So when I say universal context of IPR, I mean there are same principles which govern the implementation of IPR and which are enforced at the national level. These principles are common, which are implemented and enforced at the national level by the member countries of WTO, World Trade Organization. Broadly speaking, IPR right is territorial in nature and right is limited to each jurisdiction where IP right is granted. For example, if you want a patent protection in USA, you will have to apply USA separately. Similarly, if you want a patent protection in Japan, you have to apply in Japan separately. It is territorial in nature. So basically, IPR is a reward. IPR is a reward or incentive for intellectual labor, or creativity, which is invested in a work by conferring exclusive monopoly right to the owner. Okay? Intellectual property right confers exclusive monopoly right to the owner. In other words, patentee or the inventor. Okay, so it is a reward or it is an incentive which is given to the inventor or the patentee or the creator for their intellectual labor or creativity which goes into making that work. Okay, it's because the work is a creation of intellectual labor and it's a product of intellectual pursuit. So therefore, that is recognized that is given incentive in the form of exclusive monopoly rights. So let us look at the meaning of patent, since today's lecture will be devoted on the patent law. So what is a patent? What is the meaning of patent? Patent is an exclusive monopoly granted by the government for any technology or invention. Okay, it's an exclusive monopoly right. Okay, granted by the government for any invention or for any new technology which is invented by the inventor. Okay, so why is this right exclusive? Why is this right known as exclusive monopoly? Because by this patent right, the the owner of the patent can exclude the others from using the patented invention, from selling the patented invention, from importing the patented invention, from exporting the patented invention, or doing whatever as the whatever the owner, exclusive right of the owner belongs, these rights belongs to the exclusive right of the owner, and these exclusive rights cannot be enjoyed by the others without the permission of the owner. Okay, so this is a right, and the right is in the form of, he gets the legal right to do certain acts, like to use, to sell, to offer for sale, to import, export his patented inventions. And he can exclude, he can exclude the others from enjoying these rights without his permission. Therefore, it is known as the exclusive monopoly right. And when we go back to the history of patent law in India, historically, the current, the current Patent Act 1970, the current Patent Act 1970 was preceded by the Patent and Design Act 1911. Okay, the Patent and Design Act 1911, which was enacted by the British. Okay, and this was primarily to protect British industry and commercial interest in India. This law, the Patent and Design Act 1911, was primarily enacted by the British to protect their industry and commercial interests in India. Now, post-independence, after the independence, the government of India set up two important committees, Tek Chand Committee and Iyengar Committee, to look into what kinds of amendments or changes are required in the patent law in India, which will be conducive to our socio-economic condition of India post-independence. So these two committees were set up, and as a consequence of the report submitted by this committee, the committee suggested that product patent system. I will tell you what do we mean by product patent. The difference between the product and the process patent, I will tell you later. But this committee suggested that the product patent system, the product patent in fields of food, chemical, and medicines should be removed. Product patent should be lifted from food, chemical, and medicines. Okay, this was their main recommendation. And the patent term should be made 14 years. Patent term should be made 14 years and up to 7 years in case of food, medicine, and chemical. Okay, these were their recommendations of the committees, and which was taken up, incorporated into the parent act that we have today, the Patents Act 1970. Okay, in the Patent Act 1970, these changes were incorporated. Now, now let us come to the post WTO scenario. As we all know that India became a member of WTO, World Trade Organization, in the year 1995. and TRIPS, which is Trade-Related Intellectual Property Rights. Trade-Related Intellectual Property Rights. TRIPS is the main international treaty on IPR, which is binding on all WTO member countries. And the main objective of having TRIPS, provide basic minimum universal framework of IPR. It lays down the basic minimum universal framework of IPR. Okay, it means it lays down the basic minimum conditions and principles to be applied by all members as a mandatory norm. As a law student, you must be aware that principles play a very important role in the interpretation of law. So what TRIPS does is, TRIPS lays down basic minimum conditions to be applied by all the member countries in their IPR regime. Okay. Now, one of the main requirements of TRIPS was that all product patent should be introduced in all kinds of invention without exception. Okay, this was also one of the main requirements of TRIPS, that product patent regime should be introduced in all kinds of invention without exception. Okay, now if you recall here what I said earlier, India had lifted product patent from the field of food, chemical, and medicines. Okay, now that had to change after India became a member of WTO. Now, India had to make series of amendments in her patent law 1970 in order to make our laws totally TRIPS compliant. So we made series of amendments, one in 1999, then second one in 2002, and the third one in 2005. So to say, by 2005, we became totally TRIPS compliant. So now, after these amendments, Indian patent law provides for both product and process patent in all kinds of inventions without exceptions. Now, what is product patent? Product patent is given for inventing a new product. Okay, when an inventor makes a new product, okay, that is, patent is given on that new product, whereas process patent is given on a new process of making a product. That is the difference between the two. Okay, product patent means a patent is given on the product itself, product per se, and whereas in process patent, the patent is given on the new process of making a product. Now, difference between the two is in mainly in the fact that the patented product cannot be made. The patented product, in case of product patent, okay, I'm talking about product patent. In case of product patent, the patented product cannot be made by other person without the permission of the patent holder. Without the permission of the patent holder. All right. Now, in case of process patent, the resulting product, okay, from that process, the resulting product from that process can be made by other person by a different process than the patented process. This is also known as reverse engineering. That means, in case of process patent, okay, the resulting product can be arrived at by others through a different process than the patented process. And this is how the reverse engineering is promoted. All right. So we can say that product patent give higher level of protection compared to process patent. Okay, product patent gives higher level of protection to process than compared to process patent. Now, the question whether to apply for a product patent or whether to apply for a process patent will depend upon these factors, such as nature of invention. What is the nature of invention? What are the market conditions? Okay, what is the inventor's objective, etc. So it will depend upon these factors. Now, let us come to the basic things, basic essential factors. What is patent? What is patent? On what kind of invention will qualify for a patent? Okay. Broadly speaking, patent is given for a new invention. Any kind of new invention, invention qualifies for a patent, provided these essential conditions for granting patent are fulfilled. Provided these essential conditions are there, fulfilled. Number one, novelty. Okay, that means there has to be novelty in invention. There has to be inventive step, and the invention must have industrial applicability or usefulness. So these are the three essential factors looked into by the patent office in granting patent. Now, what do we mean by novelty? Okay, novelty, which is a very, very important, all these factors are looked into, all these factors are necessary. They are all independent. They have to be independently established. Novelty means invention would be considered novel if it is not part of prior art or anticipated or having published or in public domain. Novelty means whatever a new invention, the new invention is not already a part of prior art. It is not a part of public domain, or it has not been already anticipated. Already anticipated means it has not been published anywhere. Okay, so that is the requirement of novelty. Means the invention is not a part of prior art, it is not anticipated or having been published anywhere, or it's not a part of public domain already. Okay, now second requirement is inventive step. Inventive step. What do we mean by inventive step? Inventive step means that feature of an invention which is a technical advancement. That aspect of an invention which is truly a technical advancement, okay, in the view of the person who are skilled in that art. A person who's skilled in an art will only be able to tell whether there is a technological advancement or not. For example, a person who is an expert on mobile gadgets can only be able to tell what is the technical advancement in that cell phone, isn't it? So he is the person who is skilled in the art who will be able to tell, okay, what is the technical advancement in a given technology or in a given invention. So that is inventive step. That means you take the existing technology to a notch higher, Okay, and the third factor which needs to be established is invention has industrial applicability or economic significance. Means invention must be useful to mankind. Invention should be something which is useful to society. It must have industrial applicability. Patent is given only for technology. Patent is given only for innovations, technological innovations, and for invention which has industrial applicability or economic significance. So these are the three important factors to be established in order to get a patent. Okay. Now, next important question is where to file the application, types of patent application. Now, there can be, the application can be filed in the country where you are seeking the patent protection. Okay, so that is at the domestic jurisdiction where patent protection is sought. Because patent is a territorial right, so you need to apply in the country where you want your patent protection. Okay, so In that case, it would be domestic application, okay? Or it could be a convention application. Convention application means an application which is filed under the Paris Convention on Industrial Property, okay? So it is applicable on all the member countries who have signed this convention. Okay, so this second type of application could be convention application. And the third type of application is Patent Cooperation Treaty, PCT application. It is called PCT application. So this difference will come clear later on. Okay, each one of it have their own systems of filing and processes, has its own implication. It will become clearer to you later. Okay, so there are basically three types of application: domestic application, convention application, and PCT application. The next important question is, who can file the application? Who can file the application? Who are entitled to file the patent application? First is true and first inventor, the person who has invented who is the inventor of an invention, is known as the true and first inventor. That means an inventor, he himself can file the patent application, or an assignee of the true and first inventor, assignee, or a legal representative in case if the true and first inventor has died, deceased. So these are the three categories of persons who can file the patent application: the inventor himself, or his assignee, or his legal representative. Okay. Now, we have seen the conditions of patentability, essential requirements of patent: novelty, inventive step, industrial applicability, etc. We have seen that. But Section 3 of the Patent Act defines what are not inventions. Okay, so it is basically giving us exception to patentability. Okay, what are not patentable are defined under Section 3. All right. So we have seen the broad conditions for patent. I told you that novelty is required, inventive step, and industrial applicability is required for getting a patent. Okay. Despite having these conditions complied with, despite having these three conditions complied with, still invention can be denied. Still inventions can be denied if Section 3 becomes applicable. If any of the grounds stated under Section 3 becomes applicable, the application for patent can be denied. Okay, and what are those grounds? Let us see. Section 3. Section 3 is negative in nature because it defines what are not inventions. So following categories are not regarded as inventions under Section 3 of the Patent Act, such as if the invention is frivolous or against nature, it's not patentable. It is not regarded as invention. Okay. Secondly, if the invention is prejudicial to human, animal, and nature. Okay. For example, invention relating to chemical warfare. Invention relating to chemical warfare. That will be something which is prejudicial to human, animal, and nature. So that will not be regarded an invention. Okay. And discovery of scientific principles. Okay, discovery of scientific principles, mathematical formula or algorithms, these are not inventions. Discovery of scientific principles, because it is not an invention. There is a difference between discovery and invention. Discovery is something which discovery is already pre-existing. Discovery, the inventor only makes the findings of it. Inventor only knows about something which is already pre-existing. That is discovery. Whereas invention is something which is not pre-existing, but which is invented, which is created. So there is a difference, a distinction between discovery and invention. Okay, so these are excluded. Business idea and mental game such as mental way of calculation, mental way of calculating something would also not be regarded as invention. Okay, and then next category excluded is mere discovery of new form of known substance or new properties of known substance without therapeutic efficacy. This clause is there in section 3D, famously known as section 3D. Okay, so if it is a case of mere discovery, as I said, mere discovery will not be an invention. Always remember there is a difference between discovery and invention. Okay, so mere discovery of new form of known substance or new properties of known substance without therapeutic efficacy is not invention. This is particularly applied in case of medicines and drugs. This 3D is applied, and this 3D is also known as evergreening provision. It is also known, it contains anti-evergreening provision, section 3D. Okay, so next is any method of therapeutic, diagnostic or surgical process. Any method of therapeutic, diagnostic or surgical process is also not an invention, therefore not patentable. And any agriculture or horticulture method, any method of doing agriculture or horticulture, any method, for example, greenhouse farming, organic farming, okay, these are not inventions, these are not patentable. Okay, discovery of new living plants, animals or organisms, because they are already pre-existing in nature. You have merely discovered it. You have not created or invented it. That's the line of distinction. So therefore, discovery of new living plants, animals or organisms is also not regarded as invention under section 3 of the Patent Act. Plants or animals in whole. We cannot, in Indian law, under the Indian Act, plant or animal cannot be patented. Plant or animal cannot be patented. Plant varieties or seeds also cannot be patented, including essentially biological processes. Okay, cannot be patented. Plant varieties, we have a separate law where known as the Protection of Plant Variety and Farmers' Rights Act. Under that is a sui generis law. That is a separate law, and under that, new plant varieties can be registered. So therefore, plant varieties cannot be patented. It's excluded from the purview of patentability because there is a separate law dealing with it altogether. So, but microorganisms are patentable, and microorganisms means if there is an invention of new form of new bacteria, new algae, these microorganisms can be patentable. Okay, if it is invented by a scientist, say in a laboratory condition, okay, through biotechnology processes, through biotechnological processes, if a microorganisms are created by a scientist, it can be patented. Okay, so but remember, plants or animals in whole or part cannot be patentable. Plants, varieties or seeds and essentially biological processes are not patentable. However, microorganisms are patentable. And literary and artistic creations and computer programs per se are not patentable because these are the subject matter of copyright. Okay, so they are excluded from the scope of the patent. Invention which in effect is traditional knowledge. Traditional knowledge is not patentable. Okay, invention which is in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditional knowledge can also be not patentable. It is not an invention. This is section 3P. Section 3P. So, and any invention relating to atomic energy, okay, is also not patentable under section 4 of the Patent Act. Now coming to the next important question, that is, can the inventor file the application himself? Many people ask me whether they can do that or not, whether the inventor himself or herself can file the application or not. Yes, answer is yes. But it is advisable to take the help of certified patent agent for filing the patent application, because patent application is a techno-legal document. Therefore, only an experienced patent agent knows the requirement of a perfect application, and the patent agent will add value to your invention. Your invention will be enhanced. There will be a value addition made to your invention by the patent agent, because he has the years of training and experience with him. So it is always advisable to get the documentation ready by a certified patent agent. What is the term of patent? The term of patent is 20 years from the date of application. Okay, it is 20 years from the date of application, and this is a requirement laid down by TRIPS. Now, how long does it take to get a patent grant in India? How long does it get? I mean, the time needed to get a patent granted in India. Normally, it takes about 4 to 6 years. Okay, it's a long time. Normally, it takes about 4 to 6 years. Now, if you want to make a foreign application, how to file foreign applications? Now, for this, one very important condition for you to know is that prior permission is required from the controller of patents for filing patent application in another country. This is a requirement under section 39 of the Patent Act. Okay, section 39 of the Patent Act. Prior permission is required for foreign filing from the controller of patents. Okay. Now, I have already introduced to you convention application and PCT application. Let us see the difference between the two. And what are the benefits under both the types of application. When someone files a convention application, suppose a patent application is filed in any member of Paris Convention, in a country, in a member country, in any member country of Paris Convention, if a convention application is filed, patent application is filed, it will entitle the applicant to file another application in other member countries within a period of 12 months. That means, suppose if you file your patent application in US today, okay, then within a period of 12 months, you can file application for patent in any other member countries, say in India, but it has to be within a period of 12 months. Now, what is the advantage of that? The advantage of that is that the date of first application can be claimed as the date of priority. You will get the date of priority. Okay, and this is important for novelty. Date of priority has a linkage with novelty. Okay, so your date of first filing of application can be claimed as the date of priority. That is the advantage. Okay, you may not file on the same date in every member countries of the convention application. Convention, you may not file it on the same date. You may file it on different dates, but your first date of application you can claim it as the date of priority. Okay, you will get a priority on your invention by that. So this is the advantage. This is the advantage. And this, I will explain to you the concept of date of priority, date of priority claim. What is the meaning and what is the purpose and significance of date of priority claim? We will do that later on. Okay. So what you need to understand here is a convention application is filed in one of the member country. Within 12 months, you can file the same application in any other member country, and you can claim the date of the first application as the date of priority. Okay. Now the next is PCT application. PCT application. Now, what is the advantage of filing a PCT application? It saves lot of time and it saves lot of multiple processes involved. It can be really difficult for an inventor to file multiple applications in several jurisdictions in various countries at the same time. So this rigor and this problem is solved with the help of PCT, which helps the inventor in getting multiple applications in wherever countries you want the patent in protection, in wherever countries who are the member of PCT. Okay, Patent Cooperation Treaty, which is maintained by World Intellectual Property Organization, WIPO. So under the PCT application, one single application can be filed under PCT for grant of patent in multiple countries. Okay, you can directly file the application to International Bureau of WIPO, or through your National Patent Office as the designated office. Okay, you can you can file directly to the International Bureau of WIPO, or you can file it through your National Patent Office. There are two ways. Okay, if you file it through your National Patent Office, then your National Patent Office will be the designated office. The advantage of filing PCT application is that they also help in getting international search report on your invention. Okay, they help in getting international search report on your invention, so that you get to know whether your invention is novel or not, whether there is already similar kind of invention or same invention already made by someone else somewhere. Okay, so that international search report helps you in deciding novelty. This helps you in deciding whether you really want to go ahead with the filing of application or not. Okay, because it will save you a lot of time and money and labor, etc. So international search report is generated, okay, by the WIPO, and after that you can decide, the applicant can decide whether you want your application to enter the national phase or not, because ultimately the granting of patent has to be done within the respective country. Okay, so you have to decide whether you want to put your PCT application into national phase or not. And you get enough time for that. You get about 31 months to decide in which member countries you want your PCT application to enter national phase for their decision whether they want to grant patent or not. Okay, so this way it saves a lot of your time and money. So PCT is significant for that. I hope it's clear the difference between the convention application and the PCT application. I hope it's clear. See, all patent application is to be filed on Form 1 of the patent rules. So, you know, we have to read the act, we have to read the rules and the manual also. These three are applicable in case of patent. Okay, the act, the rules, the manuals, okay, all are very important. So application has to be filed as per the prescribed form, which is the Form 1 of as per the patent rules. And every application has to be filed either with provisional or complete specification. Okay. In case you file your application with provisional specification, then you will have to file your complete specification within 12 months. Otherwise, application will be deemed abandoned. Okay, I'm repeating. Every application has to be filed either with provisional specification or complete specification. In case of provisional specification only, complete specification will have to be filed within 12 months. Otherwise, application will be deemed abandoned. And an application shall relate to only one invention or group of inventions which are linked to a single inventive concept. That means one application for one invention. You cannot claim patent protection for many inventions in one application. Okay, it has to be one application pertaining to one invention. Or in an event where there are a group of inventions, but they are so linked with each other that it forms a single inventive concept. Okay, they are organically linked with each other. Now, I said earlier that patent is an exclusive monopoly right. Okay, patent is an exclusive monopoly right granted by the government. But in order to get that monopoly, you have to do something. Inventor has to do something. That is, you have to disclose your invention. Okay, this is known as disclosure. You have to disclose your invention to the government. So what is disclosure? Every invention has to be sufficiently disclosed to the patent office in order to get a patent. Disclosure of invention enables others to work the invention or make the invention. Therefore, every application must disclose the invention either in provisional or complete specification. Okay. So in the specification, whether it is provisional or complete, in the specification, disclosure is to be made. Okay. And the inventor has to disclose his invention. And whoever reads that document, should be able to work that invention. Okay, should help the person reading that document to to enable him to make the invention. Okay, so that is the purpose of disclosure. Okay, because the invention has to be worked, right? Invention has to be replicated. Invention has to be worked. Okay, that disclosure does that. So in specification, you are mainly making disclosure. In your specification, whether it is provisional or complete, you are making disclosure of your invention. Okay. Now, what is date of priority of claim, which is very important in patent application? What is date of priority of claim? As I said earlier, date of priority of claim is linked to concept of novelty. It is linked to the concept of novelty. Okay. Each claim requirement is each claim in a complete specification. Each claim in a complete specification must have an independent priority date. Every complete, I will come to the points, what are the contents of complete specification later on. Okay, I will come to that. I am making an important point here. Whenever you make a complete specification, whenever you write a complete specification will have claims in it. Okay. Each claim in a complete specification must have an independent priority date. Each claim must have a priority date. It's important factor. If suppose you have more than one claims in a complete specification, then each of the claim must have a priority date. Priority date of claim will depend on which date disclosure was completed. Okay, on which date you have completed your disclosure. For example, priority date, therefore, it is in the complete specification, the disclosure is completed. Normally, generally, it is in the complete specification, disclosure is completed. So therefore, priority date of claim will depend on which date disclosure that you made, disclosure about your invention was completed, on which date. Okay, whether it is on provisional application or whether it is on complete specification. Usually it is in the complete specification, disclosure is completed. Disclosure about your invention is completed. Now, what is the advantage of getting a priority date of claim? After securing priority date of claim, the inventor may disclose his invention to public without being affected by prior art or anticipation. Okay, suppose after, it means after you have made your complete specification, after filing your complete specification, okay, because your disclosure is complete with that specification, then you are in a position, the inventor is in a position to disclose his invention to public without being affected by prior art or anticipation. Okay, so after securing the date of priority of claim, you, even if you do any acts of disclosing the invention in public, it is safe. It is not going to affect your novelty. Okay, it will not be considered as anticipated. Okay, so for this purpose, priority of claim. And if suppose there you have competitors, there are always competitors waiting in the market. You know, you are not the only inventor working on your invention. You have competitors. It may happen that you, after you file your application, there is another competitor who files the application on the same invention. The question will be, who gets the priority of claim? Obviously, the one who has filed the application first with specification, complete specification, okay? Or, so he will get the priority of claim, isn't it? So for this also, it is important to secure date of priority of claim in order to protect your rights from your competitors. So what is the date of priority of claim? Date of priority of claim is the date of filing complete specification. Date of filing complete specification is the date of priority of claim. Okay. After the date of priority, even if a competitor files patent for the same invention, the earlier applicant will get the priority of claim. Okay. So this is a very important point here. And disclosure of invention to public made after the date of priority of claim will not affect the grant of patent on lack of novelty. For instance, the inventor wants to present a paper in a conference about his invention. So after securing the date of priority claim, okay, he is free to do that. He can go ahead and present his paper in the conference and disclose about his invention. This will not affect his novelty. This will not be considered as anticipated. Okay. Otherwise, before making the securing the date of priority of claim, if you go and present a paper and present your invention to the world, it will be regarded as anticipated, already published. So it will affect. It will lead to the rejection of your patent application also. All right, and during this phase, after securing the date of priority claim, the invention can even be launched or commercially worked also, because your patent is pending in that case. Your patent application is pending and you have secured the date of priority of claim. So it's safe to commercially launch, because, granting of patent, as I say, takes about 4 to 6 years. All right. And you have invested a lot in it, and you want to recoup the commercial investment that is made as fast as possible. Then this is the time, this is the right time, this is the phase where you can go ahead and launch it also without affecting the novelty or anticipation factors. Now, what are the requirement of provisional application? Okay, if you decide to file a provisional application first, what are its basic requirements? Provisional application, at one go, one can decide to file complete specification at one go also. Okay, that is also possible. If your invention is ready, when you're sure that your invention is ready and nothing more to be done, then one can go ahead and file the application with complete specification. Okay. Normally people, if it is in the stage of making, it's a work in progress, or you're not too sure and you think that there is still something more to be done with your invention, then you can decide to go with the provisional application. It must have a title of invention. This is the requirement of the document in Form 2. That is, you must give a title to your invention. Title of invention in not many words, just maybe 15 words or 20 words or so. It is given in the Form 2. In the rules, it is mentioned. Title of invention, abstract, not more than 150 words. Abstract is to be given. Description of invention. Okay, description is longer. It is longer. Description of invention, and diagrams if required. Diagrams if required. Diagrams also can be given. But in provisional application, there is no need of claims. In case of provisional application, there is no need of claims. Okay. And complete specification must contain title of invention, common between this provisional, title of invention, abstract, description of invention, but it must conclude with claims. Okay, so this is a difference between provisional and complete specification. Complete specification must contain claims. It must conclude with claims. Okay, what is claim or claims? Now, claim is the heart and soul of the patent document. It is the most important part of your patent document, considered as heart and soul. Now, claim defines the scope of invention. Claim defines the scope of your invention. It states what is that part of the invention which is to be legally protected. All right. It states what part of the invention that you want protection. Claims can be less than 10 or it can be more. All right. It can be less than 10 claims or more. All right. But claim has to be based on the description of invention that you have given. There has to be linkage between the claim that you are making and the description of the invention. The linkage has to be there. See, the main objective of claim is to protect your invention from the competitors, both in present as well as, both against present as well as future copying or even modification of your invention. Okay? You want monopoly over your invention, isn't it? And you don't want any kind of copy or any kind of modification made on your invention by your competitor, isn't it? You do not want that. So you will incorporate all these aspects within your claims in which you do not want competition, in which you want that yours is very new, novel. What you have created is novel in your invention, and you do not want others to copy or modify it, not only in the present but in future. All right. So, so you reflect all these elements in your claim. The scope, therefore, the scope of claim should be broad. Okay, it should be broad. The scope should be broad because you have to foresee future attempts on others, future infringements also, future attempts on your competitors to replicate your invention. So therefore, your claim should be broad, but without being too technical. You don't give away technical details or physical embodiments of your invention in the claim. Don't give out technical details or physical embodiments of your invention within the claim. This can go in the description part, but in the claim, you should not give out technical details. The danger is if you give out technical details, the competitor will easily catch it, innovate, and make modification and claim patent on it. All right. So claim should be clear and concise. The claim, the language of the claim should be very clear and concise and should not be ambiguous. And your claim should be based on novel features and inventive step of invention. Novel features and inventive step, technical advancement of your invention must be reflected. Novel features and technical advancement of invention must be reflected on your claim because you want protection on that very thing, isn't it? So avoid not to include in claim such features of invention which is a prior art or known already. Because what you may have what you may have invented, uh, maybe there is already a prior art. Maybe there is already a related invention in this field. Okay, so therefore, the features that are novel in your invention should only be highlighted. The features which is already a part of prior art or already known publicly, which is in public domain, should not be included in your claims, should be avoided. Okay, so claims there are independent claims and dependent claims. Okay, there are independent claims and dependent claims. So these all are part of techniques of writing a perfect claim. Techniques of writing a perfect claim. All these factors have to be kept in mind. Okay, independent claims stand independently. Okay, they are not dependent on other claims. Whereas the dependent claims depend on the independent claim. So in the claims that you make, you have to be able to, you should frame it in such a way that which are your independent and dependent. All right, because even if one of the dependent claims are struck down by the patent office, it will not affect the independent claims. Suppose independent claims stands on it, because independent claims stands on its own, and one of the dependent claims is struck down as anticipated as prior art by the patent office. That is not going to affect your independent claim. So therefore, it's good to make if possible independent claims and dependent claims. Okay. Now, there are various stages of filing application, starting from prosecution to enforcement. Now, if generally the stages of application covers these: filing of application. Okay, filing of application. It can be application can be either with provisional specification or complete specification. All right. Then thereafter, you make a request for publication. Okay, you have to make a request for publication. Otherwise, it will be considered as abandoned. It's not that you file application and you forget about it. Within the stipulated period, as prescribed in the rules, you have to make a request for publication. Depending upon as early as possible. If you really want the early granting, you have to make early request. Depending upon when you want your grant. If you are really in hurry to get the patent granted, you have to make the request for publication as early as possible. and the time period is also given in the rules. So request for publication has to be made, and after the publication, any member of the public can file for opposition against the application. So this is the time when opposition proceedings can be filed. Then thereafter, again, you have to request for examination. Don't think that they will prepare the examination report on its own. Patent office will not. The applicant has to request for examination. And thereafter, after the request is made, the first examination report will be issued to the applicant. Okay, and that first examination report will have to be replied by the applicant within the period of 6 months of the date of the first examination report. Okay, a reply has to be given, and based on that reply, later on, decision will be taken whether to grant the patent or reject the patent. All right, and this decision is also appealable to Intellectual Property Appellate Board. If you are not happy with the decision of rejection, then the applicant can appeal against the decision of the Controller General, Controller of Patent, before the IPAB, Intellectual Property Appellate Board. Okay. Now, after the grant, if any interested person wants to make an opposition, can make a post-grant opposition under Section 64 of the Act. Post-grant opposition under Section 64 of the Act. Okay, and then it is this will be followed by revocation of patent. Revocation of patent. If the opposition is successful, then it will lead to revocation of patent. Okay. Now, prosecution stage happens at the starting from the application stage, which is done at the patent office level, and to appeal made at IPAB. These are all prosecution stage. And if any infringement suit is filed before the court, the matter goes to the court. That is where the enforcement stage begins. So this was I have tried to cover as much as I could in this slide. Of course, it's a very vast area. Patent law is a very vast area. Still, there are many dimensions which I could not cover, but I think this is good enough for one lecture. Too much will also be too much to take in, Thank you.
Thank you, ma'am, for elaborating this IPR. At the same time, the patent law in a very concise manner, in fact, included most of the areas, starting from basic concept of IPR, what are included there, and in fact, domestic applications, how to file applications to get registered, basically the patents, domestic applications, then application under the convention, then patent cooperation treaty, application under it, and foreign applications. We have discussed many aspects, basically the section 3, those exceptions under Patents Act 1970, section 4, and in fact, section 39, many issues are there. Basics of IPRs, WIPO, WTO, TRIPS, and what are the committees appointed by the Government of India after independence, so that some amendments can be suggested, amendments can be made there. So to align with the international conventions, basically the TRIPS, like ma'am said, many amendments were made, like in the year 1999, 2000, then 2005. So basically the patent process, there are two processes are there. That is two types of patents are there. It's a process patent and underage product patent, which is discussed by ma'am. And ma'am also discussed the reverse engineering and basic essentials of patent, like novelty, inventive steps, and industrial and applicability or economic significance. So these are some of the issues. Apart from that, how to make international application to get the patent, and a national the role of the National Patent Office, Patent Rule Form 1 to file patent applications, provisional and complete specifications within 12 months, disclosure of information so to assess others, and at the same time to make available in the public basically those patent literatures, and the date of priority of claims. Many issues are there in claims. These are discussed by ma'am. And in fact, at the end, the patent prosecutions and enforcement. Yeah, in fact, it is very relevant in India that in patent prosecution, at least minimum 4 to 5 or 6 years has already been taken. So if a total period of patent is 20, then if 4 to 6 years are gone for prosecution, then only 14 years will be left. So in fact, maintaining the patent, in fact, renewing it yearly wise, annually wise, it's a very expensive issue. So it is sometimes it can be seen that some inventors, they always at the end, suppose 2-3 years left, before that they just waive their patentability due to inability of maintaining the annual fee because it is very high. So we are having some questions from participants, ma'am.
Yes, I can see.
Yeah. So we are having some questions here from our participants. One question is patents are sometimes considered as a contract between the inventor and the society. So basically, and the inventor is interested in benefiting the person personally from this invention. So if either of the parties are not able to fulfill the contract, can enforce. So basically, what she want to ask, this question is asked by one of our students, that is Nitisha. So basically, she want to ask that since there is a application process, and in this application process, one agreements both the parties from party 1 to party 1, that is inventors and the not society. Basically, it's the government. There's her sense is the government. So basically, in this agreement, how both the party can benefit itself. So this is her question, ma'am.
Okay. See, patent is a right, monopoly right, which is given to inventor by the government as a reward. Okay, as a recognition of the contribution that the inventor makes in the form of invention for the society. All right, so reward and recognition. It's basically a reward and recognition. So there is also an obligation upon the inventor that he makes the invention available for which he has been given patent in the country. So there is he is required to make the invention available. Okay, he has to work the invention. That is known as working of invention. Because it's not that you get a patent right and you just make the invention available only in few countries and not in a country where you have been granted patent protection. That is not fair. And there has to be a balance between public and private interests. Okay, and our law pretty well ensures that. IPR right has to be balanced between the individual interest vis-a-vis the public interest. Okay. On the one hand, it is important that we recognize the contribution made by the inventor for making something which is beneficial to society and for the development of industry and commerce. But at the same time, this right has to be balanced in the larger interest of the society. Now, I can explain this point with the help of patenting of drugs, medicines, cancer cure drugs, for example. The first compulsory license granted because we have compulsory license provisions under the law, which TRIPS allows. It's an exemption given under TRIPS. So under the compulsory license, section 84 of the Patent Act, if the inventor does not make the patented medicine available in the country, or if it is it is too expensive that the member of the publics are not able to afford it, and it is short in supply. It is not manufactured adequately. It is short in supply, and it is not affordable. It is not accessible. Then, in that event, compulsory license can be issued, and India has done that in the case of Natco Pharma case. Natco Pharma case is the first case where compulsory license has been granted for cancer drug. So after the expiry of 3 years, any interested person can apply for compulsory license on the grounds mentioned under section 84. Okay, that the drugs is not available, it is not accessible, it is unaffordable. These are the grounds. So in that case, the government can grant compulsory license to, and that's how the generic drug manufacturing companies in India have grown, you know. And India is one of the biggest manufacturer of generic drugs in the world. So so there has to be a balance between individual and public interest, even when it comes to intellectual property rights. And our laws take care of that. And compulsory. And this topic is all the more relevant because we are dealing with a pandemic called COVID-19, and there is a race for new vaccine for the treatment of COVID-19 coronavirus. There is a race. Many big pharmaceutical countries and the rich countries and developed countries and many companies in India as well are involved in the research for the development of a new vaccine. So these are very relevant questions, all right? And how do we ensure under the regime of IPR that every people of the country, whether rich or poor, gets an access to this new vaccine if developed in future? All right. So it should not be something which is accessible only to the rich and the developed countries. So whenever a vaccine is made, it should be available to all the countries, irrespective of whether they are poor or rich, you know. So let us see how World Health Organization comes up. Recently, there has been a assembly. Recently, in the World Health Organization, a special assembly was convened to come out with some resolutions to this effect. And they have recognized the fact that whenever a vaccine is developed for COVID-19, the technology should be available to all the countries and it should be shared. The technology should be shared and the vaccine should be made available. It should be accessible to all. So this is a very relevant issues that we are which is extremely important for the times that we are going through. And one student has asked me about the career opportunities.
Yes, there it is there.
Career opportunities. As an in the area of IPR.
Sorry to interrupt, ma'am. Your video is not visible here. Can you just turn on your video?
My video is not visible?
Yes, ma'am.
Can you see me now?
Still not there, ma'am.
Now? Can you see me?
Yes, now it is there.
You can see me now.
Yes.
Huh? Now, regarding career, am I audible enough?
Yes, yes.
Okay. Regarding career opportunities, let me tell you, IPR is a very, 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 very lucrative field. It's a very niche area. There are very less competition if you want to become an IPR professional, because the specialists in IPR is very, very, very less. So there are very few people who have specialized in IPR, and even in the practice side, legal practice side also, there are very few people especially in the Northeast. I've not come across anybody practicing in IPR, but in Delhi, in Mumbai, in Chennai, Ahmedabad, and Kolkata. There are many firms, especially reputed firms in IPR. Okay, and this you can also, from the career point of view, you can write the patent agent examination, which is held once in every year by the patent office in India. Patent agent examination. Uh, if you clear this examination, then you can become a certified patent agent. But for this, the educational qualification required is that you have to be a science graduate to write this exam. Science graduate or engineering graduate or any technical field. It can be electronics, mechanical, any engineering background and science background student can take this patent agent examination. And it's a good career, a very good career if you become a certified patent agent. And of course, there I can see questions on
Yes, ma'am.
GI.
Lots of questions they have putting here.
You need different
Yes.
days for this.
So basically, ma'am, there is one question on utility. So here, the participant they want to ask is whether this protection for utility or protection for the patent is it same or there is some difference in some protection degree.
Utility patent is a terminology used in US. Okay, in US it's known as design patent or utility patent. We don't use that terminology. We use that patent only in our law. Okay, utility patent is a US terminology. That's it's used in US.
So country-wise, the terminologies are quite different.
Yeah.
So another question, it is posted here by one of the students that even if lots of protections are there, basically to patents and all, but then also many violations are going on. So how to protect those violations, how to prevent those violations apart from legal protections?
Violations. See, enforcement action has to be there. Okay, you have to file infringement suit in case of infringement of your patent right. Okay, but that's a very expensive process. It takes years and years, and the judicial process is slow in our country, so it may be time taking, and it may involve a lot of financial issues are there. But of course, awareness is one thing which we can create, and this is extremely lacking in the field of IPR. There is very low level of awareness. So there has to be awareness about these IP rights in the public. There has to be proper campaigning. Government has to publicize and do more about IPR so that there is an awareness, and universities and government can collaborate in this. NGOs can take an active part in this. So there has to be more academic sharing, academic publications, research works being published, talk more about IPR in media, in newspapers, write about it, talk about it. That's how we build awareness, isn't it?
Ma'am has answered a lot of questions. I think many questions are there, but it is not practically possible to take all the
Yeah,
questions.
how to register a GI, I can see that.
Yeah,
It's
many questions. Yeah, people say
many
posted. Hmm. So,
trade secrets also there is question. That
so
means students are
yeah,
aware of this subject. They
yeah.
know about
So basically, this
traditional
IPR
knowledge.
area of IPR is very vast. So
Yeah.
this includes different lecture series on it. Since we are
Yes.
having a limited time, that is 1 hour and 1.5 hours. So apart from the sharing of vast knowledge which ma'am possesses and she has shared with us, I would like to add a few points here. So those points are basically this innovativeness and patentability. It is there, no doubt. But to innovate, people must have that mentality of innovations. So basically, I have just prepared some of the data. I have collected some of the data which is published by good institutions. Here it is mentioned that in 2017, over 6 lakhs applications were filed in US. China twice, it is 12 lakhs. And in India, it is only 46,000. And from these applications, only 12,000 were granted. That's the patent applications out of 1.37 billion people. So question is, in India, many researchers need to be produced so that they can innovate, they can bring something new so that they can at the same time file these applications to get the grants, to get the patent grants. So in fact, under the PCT, many overseas filings are there. In fact, most of the overseas filings, basically in India, it is filed by US domiciles. In fact, in the year 2017, more than 2 lakhs 30,000 applications were filed from USA in India, and Japan 2 lakhs. But in India, in case of filing overseas application, it is very less. It is only 13,000. And in fact, the Qualcomm is the biggest patent filer in India. It is a foreign applicant in the year 2018 and 2019. And in fact, the number of researchers, if we see per million people, then Japan have 5,213, and US 4,000, and China 1,200. But in India, researcher per million is very less. That is only 216. So here, we need to produce more researcher, more scientific-oriented mind, so that there can be more innovations. When there is innovation, there can only be patent. They can only file the patent. So apart from that, in India, like most of the IITs, they only file these patent applications. It's the data of 2018 to 2019. 557 patent applications were filed by the IITs India, and in fact, out of which, other than that, Chandigarh University has filed 336, and TCS filed 239, and then CSIR has filed 202, and Bharat Heavy Electronics have filed 173. So basically, other than IITs, the other conventional universities, even if they're having lots of advanced research centers, but then also the filing of application for patent is very less. In fact,
have you
yes,
tried to understand the reasons why there is less filing of applications?
yes, ma'am. That's a very concern issue. Why we are having less number of filing issues here in India? So if you just just throw some lights on it, then it will be well and good.
Maybe it could be because, again, I would like to say here that people, maybe they are not aware of the processes involved. Maybe they are doing it and maybe they are not doing it in a proper way. And maybe there is not a proper system created for that in the universities. It could be that because you require a professional assistance in this. You may have a very good invention and in hand, but you don't know how to go about it, how to protect it, what are the processes involved in getting a patent. So that will be a handicap for you. Okay, you may have a great research publications, which may lead to a wonderful invention, a very a new invention. But the thing is, when you don't know how to go about it, how to file it, and the technicalities involved in it, then it can be a handicap. So this area requires thorough. I mean, there has to be some kind of a mechanism established whereby the inventors are helped in filing the applications.
It's very true, ma'am. Awareness is required.
Yes.
Basically, this IPR regime.
Institutional support,
Yes.
awareness as well as institutional support is to
Yes,
be.
institutional support, and in fact, I would like to add on with it. So basically, from our GDP, gross domestic product, like in India, out of it only, like I have done some research on the statistical data, only 0.7 to 0.8 are invested on R&D, research and development. But if we compare it with other countries, like for example, highest topmost is the Israel. They spend 4.3% of their GDP on R&D, research and development, and US 2.8% is, China 2.1, and Korea very high, that is 4.2. But in India, it is only 0.7 to 0.8.
Very
So
disappointing.
yeah, very disappointing. In fact, awareness is needed. research, good public research are needed, but at the same time, we need that sponsored. So many inventions are going on under some sponsorship.
More government funding is required.
Yeah, mainly government funding for R&D, research and development. In fact, yeah, that is in fact one of the reports by Economic Advisory Council to the Prime Minister target that R&D, research and development expenditure, it will be raised up to 2% by 2020. So we are hoping for some good. In fact, recently one global intellectual property index of 2020, it has published that India has ranked 40 out of 53 countries. So it is a good sign. And we hope that government of India invests more its resources to technology-based, research-based. In fact, quantum and technologies, they're investing on it. I think more than 65,000 crores are invested now by this Union budget in 2021. So we are hoping for some good result. By 2020, we will have more investment and more allocations of resources there into the R&D so that we can have more developments, mainly the scientifics and all. In fact, sponsor research is very needed so that a researcher at IITs, in fact, we law people from law background, we can also contribute some, developments there, mainly the attorneys side. So with this, I would like to conclude. Ma'am had contributed a lot, in fact, shared her valuable knowledge from the basic up to prosecutions, patent prosecutions, and many issues are there to be dealt with. We will have another session. We are hoping and we are looking forward to seeing again. Thank you, ma'am, for your valuable time, for sharing your valuable time, for sharing your expertise. We will organize again. We will see you again. Thank you, ma'am. And at the same time, I would like to thank all the participants for sparing their valuable time here. And all the e-certificates will be distributed within 1 or 2 days. Thank you, everyone. Once again, thank you.
Thank you once again, and all the best to all the participants. See you again. Bye.